All right, I'm going to call to order. Good morning, ladies and gentlemen. I'm going to call to order the 127th public meeting of the Massachusetts Gaming Commission. Good morning to you all. Before we start, I want to just say a few remarks to set the stage for the meeting and the agenda and why we're here. We've called this meeting to discuss the City of Boston's motion to stop all proceedings regarding issuance of a Category 1 gaming license in Region A until after the outcome of the November 4 ballot initiative. By way of what is now largely familiar background, the legislature granted the Commission all powers necessary or convenient to carry out the purposes of General Laws 23K, the expanded gaming legislation. Chapter 23K provides that power and authority are to be broadly construed in order to allow the Commission to implement, administer, and enforce the gaming laws. Pursuant to Chapter 23K, the Commission is the sole entity with the authority to issue licenses and is required to issue or consider issuance of one slots parlor license and one expanded gaming license in Regions A, B, and C. We're now focused on Region A, which is the eastern part of Massachusetts, the northeastern part of Massachusetts, and more specifically, because of the identity of the two applicants, the greater Boston area. On June 24, the Massachusetts Supreme Judicial Court announced its decision in the case of Abdow against the Attorney General, as a result of which the question of whether to make expanded gaming as defined in Chapter 23K illegal will be placed before the voters of the Commonwealth as part of a ballot for a statewide initiative vote on November 4. On June 27, 3 days after the SJC's decision, the City of Boston filed a motion to stay all proceedings, not simply a motion to stay issuance of the license, but a motion to stay all proceedings regarding issuance of a Region A license until after the November 4 vote. The city alleges that a stay is necessary to prevent Boston from incurring considerable expenditures of time, money, and effort in connection with the license proceedings, in particular for the negotiation or arbitration of a surrounding community agreement with both of the Region A applicants. All other surrounding communities in Region A have completed those surrounding community agreements. The focus of this meeting then will be whether the Commission should grant the city's request and motion to stay the proceedings. As it frequently has done, the Commission has solicited public input before making its decision. And as part of the June 27 notice for this meeting, as well as postings on the Commission website, the Commission outlined the process by which it would receive public comment. The process was designed to ensure that comment would be received in a fair but uniform manner. And in addition to the public comment, the Commission invited a representative from the City of Boston, the City of Everett, the City of Revere, Mohegan Sun, Massachusetts, LLC, and Wynn, Massachusetts, LLC, the entities that would be most directly impacted by the grant or denial of the requested stay, to appear before the Commission and offer comments on the motion. Each representative has been allotted 15 minutes with which to make comments. In reviewing the motion before it, the Commission may ask any questions, review and consider any documents or any other sources of information, including comments received as part of the request for public input. After the oral presentations, the Commission will discuss what it's heard, what it's received in writing, and may make a decision immediately or defer a decision until a later date. We've set the auditorium up so that everybody can be seen by each other and be seen by the audience at the same time. So I would ask the representative or representatives of the City of Boston, the City of Everett, the City of Revere, Mohegan Sun, and Wynn, Mass, LLC to take a seat here, and we'll proceed in that fashion. We've received a request for two representatives of the city, and I think we have sufficient chairs for both. All right, do any of the commissioners have any introductory remarks or comments before we begin? If not, then if I might, let me turn to the City of Boston for its presentation. Mr. O'Flaherty?
Good morning,
Good morning.
Good morning.
Mr. Chairman, and through you to the commissioners. As the commission is aware from its open and introductory comments, the city has moved for a stay of all regulatory proceedings in Region A in light of the SJC's opinion in Abdow versus Attorney General. In that decision, as you are aware, the matter of the initiative petition to prohibit casino gambling is headed to the ballot in November. As a result of that, voters in the Commonwealth will decide whether to appeal or endorse the Enhanced Gaming Act this fall. The vote will occur on November 4th, which is 4 months away. The current status of Boston's discussions with the applicants is as follows. Boston has engaged in negotiations with both applicants. Boston has not reached an agreement with either applicant. One of the parties, Wynn, the proponent, has sent notice to initiate arbitration to commence today. The arbitration period with Mohegan has been scheduled as well. The city has sent a letter to both applicants stating that given its pending motion to stay, it is refraining from the arbitration process until the commission decides the motion. In determining whether to grant such a stay, as Your Honor knows, and as the commission members know as well, the standard used by the courts in analogous situations is instructive. The courts apply a four-part analysis. What is the likelihood of success? What is the irreparable harm if no stay is granted? The balance of harms to the parties involved and the public interest. One of the most compelling reasons to grant the city's motion is that the city will suffer irreparable harm without a stay of these proceedings. If there is no stay of the proceedings, and if expanded gaming is repealed in November, the entire licensing proceedings will be rendered moot. This means that the city will have needlessly expended significant amounts of money, time, and effort engaging in negotiations and arbitrations with the applicants. Arbitration, especially, is time-consuming and very costly. If no stay is granted, and if the repeal measure passes in November, the city will have no remedy to recoup any of the funds it will have expended. It is our position that this constitutes irreparable harm and should weigh heavily in favor of a stay. A stay is in the public interest as well, because any action the city takes with respect to negotiation may unfairly impact the voters in November. In contrast to the irreparable harm the city will suffer if there is no stay, the applicants and the commission will suffer no prejudice if a stay is granted. The stay would create only a short delay of 4 months until the November 4th elections. If the repeal measure fails in November, the parties can resume the proceedings immediately, resulting in no prejudice. The applicants are well-heeled entities and will continue to generate revenue in their respective businesses over the next 4 months. In fact, they may wish to spend funds on campaigning against the repeal measure during this time. Moreover, a stay would only delay the regulatory proceedings before the commission. The applicants are free to continue other work on their casino proposals, such as environmental assessment and permitting. The host community agreements with Revere and Everett would also stay in effect. And finally, the commission would suffer no prejudice due to a stay because it has flexibility over its timeline, which it has itself publicly acknowledged. Therefore, the balance of the harms in this instance weigh in the favor of granting a stay. What would be the likelihood of success? In this case, in the repeal of expanded gaming. If expanded gaming is likely to be repealed, then this factor would favor granting a stay. The public support has been up and down on the Gaming Act, and lately, some would argue with certain polls it's on a downward trajectory. Polling has shown support for the repeal measure in some instances steadily climbing over time, with most polls showing a dead heat. One poll conducted by Suffolk University and the Boston Herald last month showed that 40% of likely voters disapproved of casinos, as compared to 37% who approved. Given this trend, it is likely that opposition will continue to grow, making it likely, not certain, but likely, that the repeal measure will pass. Public interest. Boston's funds are public funds, so it is in the public interest to spend them judiciously. If these funds were spent on proceedings that are rendered moot by a vote for repeal in November, they will be lost forever to the detriment of the public. If there is no stay of the proceedings, and if Boston enters into any agreements with the applicants, the terms of the agreements may impact the voters' decision one way or the other. It would be more prudent for a stay to preserve the status quo until the voters have had a chance to voice their opinions at the polls. In the memorandum that we provided you, we were unable to find any Massachusetts cases on point, but we did find cases from California involving citizens' referenda that have held in favor of staying proceedings and preserving the status quo until voters have had their say. Today, you will hear from the proponents, both proponents, and in front of the pleadings that have been presented in front of the commission, that a stay of the Category 1 license proceedings in Region A is contrary to Article 48 of the Massachusetts Constitution. I believe that that is incorrect, and council, in our review of this matter, believes that the city is not seeking a suspension of General Law, Chapter 23K. The city is only seeking a suspension of the licensing proceedings with respect to Category 1 proceedings in Region A. You will hear proponents argue that the four-factor test under 205 CMR 102.034A controls. This is incorrect because the city is not seeking a variance of regulations. The city is seeking a stay pending the outcome of the initiative petition in November, which could render the entire licensing proceedings moot. This is analogous to seeking a stay of legal proceedings pending a future event, which is why the test used by the courts to consider stays is instructive. You will hear the proponents argue, quite possibly, that the commission has the power to delay deadlines and concede that they have the power to delay deadlines in the licensing proceeding. A 4-month delay will not render the proponent's applications unreliable. If it did, then the soundness of the application was questionable to begin with. The public interest is served by the voters having their say. The citizens of East Boston and Charlestown will finally be able to vote on whether they want a casino in their community. In fact, it is the applicants, in continually objecting to Boston's assertion of host community status, who have consistently worked against the ability of the people to vote. Moreover, Mohegan Sun and Wynn's public interest argument is premised on the assumption that the commission will grant a Category 1 license in Region A. This is speculative. The commission is not required to grant a license. The proponents will argue that the initiative petition will not pass, relying on polls from earlier this year. However, it'll be interesting to hear if we hear of the downward trend in the same matter when they speak. One poll conducted by Western New England University Polling Institute showed statewide support for casinos by a 60 to 33 margin. The cases that will be cited by the proponents regarding irreparable harm are inapplicable to our facts, because the courts were addressing the expenses and costs to private for-cost companies. The City of Boston is a municipality. We are funded by the taxpayers, and the expense and burdens the city incurs are at the expense of the public. Once again, the proponents' arguments with respect to harm that other parties may suffer are premised on the assumption that the commission will grant a license at all, and specifically to one of them or the other. The City of Revere's budget cannot depend on the award of the license to Mohegan Sun, whether or not a stay is granted, as well as the City of Everett. On the other hand, the costs and financial impact to the City of Boston are real and immediate if a stay is not granted.
Could I interrupt you just a second, Mr. O'Flaherty? We're broadcasting this so that people who aren't here can see what the proceedings are, and the screen down here at least just went blank, so I want to see if the broadcast feed is still up. It is? Okay. Sorry for the interruption. Go ahead.
In conclusion, the City of Boston will be irreparably harmed, as will the electorate, as any actions could be construed as potentially influencing the vote in November. If a license issues or licenses issue and agreements are signed before the vote, then the question has to be asked, whether that ballot question will be compromised. Each of the 4 factors that the courts weigh when considering a stay are in favor of granting a stay of all Category 1 license proceedings in Region A. The city respectfully requests the commission to grant its motion to stay. Thank you, Mr. Chairman.
All right, sir, thank you. Questions for Mr. O'Flaherty? I have some questions, but I'm going to wait till the end and come back with questions at the end.
I'll do the same.
All right? Okay. All right, the next in the order that we've chosen, alphabetical and hierarchical, Everett is next. Mayor.
Thank you, Commissioner. Thank you, Commissioner and members of the Commission. I'm going to share my presentation with, on my time, with my counsel from Copeland and Page, Jonathan Silverstein. I'm going to be very brief. I'm probably the only one on this panel who's not an attorney, so I know that they'll take up most of the time. So I'm going to be very brief. Mr. O'Flaherty made one good point that the people of Charlestown, the people of East Boston will have the opportunity to vote. If I'm a voter in one of those communities, I think I would want to know where the casino is going to be sited. That will impact my vote, where it's going to be sited. I think we have a great opportunity here to go into the November election, people knowing where the casinos are going to be sited, and they may have certain reasons. People who are environmentalists may want to see that the Monsanto site gets cleaned up. People who are in favor of other things that the Revere application has may want to see that go there and have a reason to vote for it there. People who in different surrounding communities have different reasons to vote for an application or not to vote for it. I think we have a great opportunity here. People in Everett voted over a year ago, been dotting their I's and crossing their T's and waiting for the day in September that they're going to get to know if they're getting a license or not. To keep laboring this and be late, and just putting it off, it sends a bad message to people in the Commonwealth that we can't get our act together. I think this is great that you're going to allow us to speak today. I don't see the harm that is caused by awarding the license. We've time and time again, I know we try to deal with Boston and negotiate a surrounding community agreement. They're in a great opportunity to be able to negotiate 2 surrounding community agreements. I think let's just get this process going. Let's vote for this license in September. Why keep waiting? If it doesn't pass, I mean, so we talk about the polls, and we all know polls. As soon as people start spending money, it changes people's minds. There's a reason why we passed gaming in the Commonwealth, because 60–70% of people from Massachusetts were going to Connecticut to game. That's revenue that could be in our state that was going elsewhere. And once that's put back out there, once people know that $200 million of the gaming revenues are used to offset this year's budget, that's going to be cuts of services to residents in the Commonwealth. I think once all that information is put out there, these polls are all going to change. So I feel, as the only elected official currently in office, other than Mr. O'Flaherty, who served in office, I think people are disheartened to know that this process is keep going on and on, and that's maybe why there is voter fatigue out there. I say we get this going. We've done all the work in Everett. We've done what you asked us to do. We've gone above and beyond. We'd like to know if we're going to get the license in September, not wait till November, because it affects how we're going to operate the next couple of months after that. And if I could invite Jonathan Silverstein from Copeland and Page, who's been representing the city of Everett for the last few years now, but the last year on our host community agreement and all of our dealings with the casino. Thank you, Mr. Chairman. Thank you for your time this morning.
All right, Mr. Mayor, thank you. Thank you. Mr. Silverstein, you have 10 minutes of unexpired time.
Thank you, Commissioner. Again, thanks for the opportunity to speak to this matter today. I want to begin by suggesting to the Commission that the standard articulated in the City of Boston's motion is not the appropriate standard. I think under that standard, the motion should still be denied, but Mr. O'Flaherty suggested that the appropriate standard is the standard applied for stays in litigation. Litigation, as the Commission knows, is an adjudicatory process. The Commission could not have been more clear in its regulations that the Phase 2 licensing process is not an adjudicatory process. It said it explicitly in its regulations, said it's a legislative process. and then administrative process. The commission has set a schedule, and I would suggest that its schedule is much more analogous to its rulemaking and regulatory process than it is to litigation. And if the city wants the commission to vary from that schedule, I would suggest that the appropriate standard to apply would be the commission's variance standard. And that standard requires a finding, a demonstration by the movement, and a finding by the commission that granting the variance or the waiver would not interfere with the commission's fulfillment of its functions. And I would suggest that the effect of granting the City of Boston's motion here would be just the opposite. It would substantially interfere further with the commission's fulfillment of one of its core functions, the issuance of a license in Region A, which I think is probably the most watched region, the most watched license that this commission's been addressing statewide. So I would suggest that the appropriate standard is your waiver standard and your regulations, and under that standard, there's absolutely no doubt that the motion should be denied. Now let's assume, for argument's sake, that the appropriate standard is the four-part test that's articulated in litigation. First of all, there's absolutely no irreparable harm to the City of Boston. Irreparable harm has been repeatedly, there's case law longer than my arm that says that it cannot be financial in nature. That is all that the City of Boston has articulated, financial harm, that they're going to have to spend money on this process. Well, respectfully, I understand that the City of Boston is a very important city in Massachusetts, but every other community, every other surrounding community in this Commonwealth has gone through the process of either negotiating a surrounding community agreement, or if unable to do so, arbitrating a surrounding community agreement. And I don't think that Boston is so special that it should be exempt from that process. And it's not an irreparable harm to be forced or required to undergo the process that every other surrounding community has undergone. And the financial harm that Boston cites is not irreparable. Even if it were a cognizable harm under the standard, it's not irreparable. Why? Because the statute and your regulations clearly state that a surrounding community is entitled to recover exactly those reasonable consulting fees that it expends in the process of negotiating or arbitrating a surrounding community agreement from the applicant. And that's been done repeatedly. It can be done through the involuntary disbursement process, or it can be done through the arbitration process. And I can speak to that from experience, having included exactly that provision, and Commissioner McHugh tweaked it a little bit in West Springfield with respect to the MGM proposal. So it's not a cognizable harm, and it's not an irreparable harm. On the flip side, I think the harm to the Commonwealth, to the applicants, and to the potential host communities are extensive, are irreparable, and are substantial. Boston refers to this as just a mere 4-month delay. It's a mere additional 4-month delay. The City of Boston has advocated strongly and repeatedly on its behalf before this commission, and that prior advocacy, repeatedly asserting host community status, repeatedly being rebuffed by the commission, has resulted in its own delays. So it's not just 4 months, it's just an additional 4 months. But that 4 months, I suggest, is of a very substantial nature in its impacts on the applicants and the communities and the Commonwealth. Just by way of example, that 4 months, delaying commencement of operations, if the license goes to Wynn Everett, that 4 months translates into over $8 million of lost host community payments to the City of Everett. Unrecoverable. There is no process for the city to recover that. There's no process for Wynn or Mohegan, if they get the license, to recover the lost profits, lost revenues that delay would engender. There's no process for the Commonwealth to recover the tens, possibly $100 million of lost revenue that these delays will result in terms of reduced gaming tax revenue. There's no ability for the individuals who would be employed at these facilities to get back the jobs and the employment that they would have for that 4 months and the other months of delay caused by the City of Boston's prior efforts. So I would suggest that if we're going to be balancing harms, financial or otherwise, there's absolutely no harm to Boston by denial of their request, and there's substantial harm to every other stakeholder in this process. I want to also note that there's nothing new here. It's not a surprise that there may be a repeal question on the ballot in November. Everyone has known about this for a long time, and every stakeholder, every surrounding community, every applicant, the commission itself, haven't buried their heads in the sand in hope that it would go away. As the Supreme Judicial Court noted in its Abdo decision, everyone understood coming into this process that there is a risk of repeal. There's a risk that if it fails now, in 5 years it could come back. For the commission to be paralyzed in its core function of licensing the Region A Category 1 facility, I think makes absolutely no sense. With that, I'll rest and refer the commission to my written comments, and happy to answer any questions. Thank you.
All right. Thank you, Mr. Silverstein. Questions from members of the...
I'll reserve them to the end, too.
You're going to save some for the end as well? All right, fine. Thank you. We'll hear next from the City of Revere. Mr. Falk.
Thank you, Commissioners. Brian Falk from the law firm Myrick O'Connell, Special Counsel to the City of Revere. The City of Revere appreciates this opportunity, but is disappointed to appear before you yet again to discuss a topic initiated by the City of Boston, completely unrelated to the merits of the Region A licensing process. 2 months ago, Boston asked the Commission to determine if it was a host community to 2 projects located completely outside of its borders in neighboring cities. Now, as just one of many surrounding communities to these projects, Boston asked the Commission to ignore its statutory duties and suspend the licensing process for several more months. Revere opposes this latest attempt by Boston to further delay the licensing process at the expense of everyone else. Revere submitted its written comments yesterday and also agrees with the written comments submitted by Mohegan Sun. Perhaps for the first and only time, Revere finds itself in complete agreement with the City of Everett and with Wynn in their written comments.
Well, that's progress.
In summary, Revere finds that Boston's motion is procedurally out of order, given the clear variance criteria set forth in the Gaming Commission's regulations. Revere finds that Boston's motion is contrary to the initiative petition process set forth under Article 48 of the state constitution, which does not compel an administrative agency, such as the Gaming Commission, to ignore its statutory duties pending a referendum vote. Assuming for the sake of argument that Boston has put forth the correct legal standard, Boston's motion should still be denied. First, Boston asked the Gaming Commission to act as a political pundit and predict the outcome of the November referendum 4 months in advance. The Gaming Commission has no legal basis to gauge the likelihood of success in November and should not base this important decision on current opinion polls. The most recent opinion polls currently favor a no vote in November, a fact omitted from Boston's motion. Boston next asserts irreparable harms if the Gaming Commission does not suspend the Region A licensing process. Those harms concern fees and expenses associated with Boston's surrounding community negotiations. However, most of these costs, if not all, as mentioned by Attorney Silverstein, subject to reimbursement from the 2 applicants and from the Gaming Commission's grants. It doesn't render them irreparable harms. Boston's motion also glosses over a major element of its stated legal standard, which is the balance of harms among the parties. Boston's stated harms are largely subject to reimbursement. Revere's harms are not. Aside from the delay of tens of millions of dollars in tax revenue, thousands of jobs, a delay would also cost short-term irreparable harms to Revere. Under Revere's host community agreement, Revere will receive an initial payment from Mohegan Sun of $6 million within 30 days of the license award. That's equivalent to 3.75% of Revere's current operating budget. If the license award date comes after the November election, sometime next year, Revere cannot build this payment into its tax rate, meaning homeowners and businesses in Revere will pay a higher share of taxes than would otherwise be the case. Revere cannot refund these taxes once the $6 million payment arrives late. The late payment may also affect the city's bond ratings, increasing the cost to borrow for needed municipal projects. All of these harms would be irreparable and not subject to reimbursement. For a sense of scale, Revere's $6 million payment is the equivalent to 3.75% of our operating budget. For Boston to face the same comparable harm to its $2.7 billion budget, its unreimbursed negotiation expenses would need to total about $101 million. In addition, Revere will receive $2 million from Mohegan Sun within 30 days of their financing date. This money will reimburse Revere for renovations to its football stadium. If the license award date comes after the November election, Revere will not be able to retire its existing debt for the stadium project, costing additional interest, tying up the city's borrowing capacity. Again, these harms are not subject to reimbursement. With respect to the time and resources of city officials, Revere officials have spent countless hours meeting with Mohegan Sun representatives on permitting matters to prepare for the award of a license. Every time the license award date is pushed back, schedules, bid documents, and weeks of work must be amended. Revere has a strong team, but not a deep bench. Time spent by our officials dealing with licensing delays takes time away from other important matters. Another harm to Revere concerns lost economic development opportunities. Revere anticipates significant economic development investment in the form of ancillary projects near Mohegan Sun and Revere Beach if the license is awarded. But selling Revere to developers gets harder and harder each time the license award date changes. Our Economic Development Director, John Fesser, who's with us here today, has seen developers walk away due to uncertainties in the licensing process. Delaying the license award yet again will force potential developers to decide between waiting indefinitely for a license award or pursuing opportunities outside Revere. Given Revere's financial constraints, a single lost economic development opportunity is one too many and an irreparable harm. Delaying casino development and ancillary projects also delays Revere's revenue from these projects. Given Revere's financial situation, this is an irreparable harm that hurts Revere's existing residential and commercial taxpayers. In contrast, our Economic Development Director's counterpart in Boston, the multi-million-dollar Boston Redevelopment Authority, may preside over billions of new development regardless of where the Region A casino is located. Finally, Boston suggests that the public interest requires a suspension of the licensing process. To the contrary, if voters are to make an informed decision in November, they should know the location of the Region A casino, likely the most lucrative of the license awards. Voters should see the Expanded Gaming Act implemented in real time, not suspended unnecessarily after 2 of the 4 licenses have been awarded. It's unfair of Boston to ask the Gaming Commission to ignore its statutory duties in order to influence the vote in November. Such action would clearly go against the public interest. Revere urges the Gaming Commission to keep the licensing process on track and deny Boston's motion. Thank you.
All right, Mr. Falk, thank you. Colleagues, any questions for Mr. Falk? All right. Let's proceed now to the Mohegan Sun. Mr. Barnett.
Thank you, Commissioner McHugh. Commissioners, I'm happy to be here today. I appreciate the opportunity to speak on behalf of Mohegan Sun. I'm Bruce Barnett from the law firm of Daylight Piper. The Expanded Gaming Act is the law of Massachusetts. It was enacted by the legislature, it was signed by the governor, it's been in effect for over 2.5 years. It was not done on a whim, to say the least. It was the product of a very careful legislative weighing of all the factors involved in such a significant decision. The legislature established the policy of the state to be in favor of the jobs, the revenues, the ancillary economic developments and activities that expanded gaming will spur, while providing for unprecedented mitigation of community and social impacts. This commission is the creature of that legislation. It's charged with implementing the statute. It's been moving as quickly as it can to bring those benefits to the people of Massachusetts. I'm sure you don't need me to remind you of the many, many times the commission has been criticized for acting too slow by people in the press or public discourse. But you've moved as quickly as prudence allows in light of the many and complex tasks that the legislature gave to you. But the City of Boston now asks that you suspend the licensing process for Region A for more than 4 months for a reason that has nothing to do with careful implementation of the statute. Rather, at least with respect to Region A, the city asks that the commission behave as if the statute were different, as if the referendum had already passed, and as if Chapter 23K and the other relevant statutes had already been amended. The law that would be approved if the petition were succeeded on the ballot in November is brief. It amends existing law. Technically, it doesn't repeal Chapter 23K, but in the second of its 2 substantive sections, It provides that the commission is prohibited from accepting or evaluating or approving any application for an expanded gaming license. As I said, Boston asks the commission to assume that the amendments proposed by the initiative petition have already been in effect and that it cease its review, evaluation, and action on the Region A petitions. Doing so is contrary to the commission's legislative mandate to implement the Gaming Act and bring its benefits to Massachusetts, and Mohegan Sun asks that you deny the request. Giving anticipatory effect to the initiative petition and suspending the operation of Chapter 23K, at least with respect to Region A, is also contrary to the carefully balanced approach of Article 48 of the amendments of the Massachusetts Constitution. In making this comment, which is put forth in more detail in our written submission submitted yesterday, we're not saying that there would be a technical violation of Article 48 if the stay were granted. Article 48 doesn't govern the commission. But Article 48 does, we submit, represent a careful consideration of the effect of the exercise of popular legislative action on existing duly enacted laws in Massachusetts. You may have noted that in my comments so far today, I've tried to be careful to say initiative petition, not referendum. The ballot question for November is popularly referred to as a referendum in the press, by those of us involved in the process, by me in my own casual conversations. But it's not. As a constitutional matter, it's an initiative petition. The distinction is set forth in Article 48, which governs both of them. The initiative is the power of a group of voters to submit either a constitutional amendment or a new proposed law to the rest of the electorate at an election. A referendum is the power of a group of voters to submit a law that has already been enacted by the legislature to the voters for approval or rejection. The constitutional distinction is relevant to the question before the commission today because Article 48 provides for the suspension of the operation of a law that is subject to a referendum, but not for suspending the operation of a law that would be changed if an initiative were passed. Newly enacted statutes can be suspended pending a referendum because they've never been in effect. In fact, the reason why Massachusetts statutes take effect 90 days after they've been enacted by the legislature and signed by the governor is to allow time for someone to bring such a referendum petition. But the balancing goes further than that because not all laws that are subject to the referendum provisions are capable of being suspended. First of all, the petition has to ask for a suspension. Here, the people who signed the petition to put the initiative petition on this November's ballot were not asked to support a suspension of the law pending the vote. Also, the suspension provisions don't apply in the event that the law under review or subject to change is was enacted as an emergency law, as this one does. And so the Article 48 point is this. The framers of that provision of the Massachusetts Constitution struck a careful balance, carefully contemplated as to when a validly enacted law should be suspended pending a vote through the popular legislative mechanisms. It's possible for a referendum. It's not possible for an initiative petition. And granting Boston's request would be contrary to that balance. But the request not only asks the commission to suspend the statute it's charged with implementing, it also seeks a variance from the commission's duly enacted regulations. The city of Boston says, no, it's not a variance, it's a stay. Well, on its face, they don't call it a variance, but there is no way to implement the stay without altering the deadlines set forth in the commission's regulations for the surrounding community process. The content of the motion, the content of the letter that was submitted on Monday by the city of Boston to both the applicants and copied to the commission, and the content of their comments here today make clear that the concern, the object of their stay, is to forestall the required actions on their part to go through the surrounding community process. And you've heard already this morning some of the requirements of a variance from this commission, and you're obviously well aware with them from having dealt with many. But to frame them in the light of the request before you, in order to find a variance warranted from those regulations, you would have to find that each of the following is true. Granting the stay must be consistent with the purposes of Chapter 23K. Granting the stay must not interfere with the ability of the commission to fulfill its duties. Granting the stay must not adversely affect the public interest. And failure to grant the stay must cause a substantial hardship. Each of those, not just one or a combination of majority, on balance, The regulations require each of those requirements be met. I think what I and others have already said today demonstrates that the city does not meet either of the first two criteria for a variance. As to the purposes of 23K, unnecessarily delaying the benefits of expanded gaming, jobs, tax revenue, ancillary economic activity and development is antithetical to the purposes of the statute. It's not just not consistent with them, it's directly opposed to them. And it follows that the stay would interfere with the Commission's duties, which is to implement the statute and bring those benefits to the people of Massachusetts. The city made a reference to the reliability of applications, which I believe is a reference to a comment that part of our comments with respect to potential staleness of the applications if the stay were granted. And the point we're making there is this. The applications were filed on December 31st, 2013. You know better than anyone how complicated they are and how in-depth. You know they were in the works for some time before that. When they were filed, it was anticipated by the Commission through its public statements that the award decisions for both Region A and Region B on the Category 1 licenses would be made by the end of May. And then it was delayed a month to the end of June because of a need to replace a contractor in the surrounding community petition process. And then it was delayed to mid-August and then to the end of August, early September timeframe we're currently working on as a result of proceedings related to Boston's status and extensions requested by the city. If we have the stay now and nothing is done by either the Commission or the applicants with respect to the licensing process until after the November election, we're going to be into 2015 at the earliest before you can be possibly granting a license. Why do I say that? We sit here at the beginning of July and there's 2 to 2.5 months of activity left, intense activity on the part of both the Commission and the others in the process to get to the current September, mid-September timeframe. So you tack that on to the end after the November election, we're talking into January. And frankly, we don't know that the process between where we are now and getting to the designation or the award of the Region A license will be as smooth as perhaps it's been in other regions or as we might hope it would be. The Region A process has been different all along the way, and granting the stay would forestall getting to the unfolding of that process to see what lies in store for us. And when you talk about evaluating and ruling on applications that have been sitting for over a year, I think it's fair to question in a way then that it wouldn't be appropriate to do yet. Is all the information, are the projections, the economic analyses that are built into those still appropriate? Would the Commission feel the need to solicit updates, refreshments, redo work that its consultants have already done at that point to bring them into currency? And I think that is a reasonable thing to consider. On the public interest point, others have spoken about it. I want to make a couple of additional points. One, the Commission's well aware of the impact of the licensing fees on the state budget process. Originally, the plan and the hope was that the licensing fees would be collected and for use of the state in the fiscal year that ended 2 days ago. Unfortunately, that didn't happen. The legislature has just reached a budget deal, according to the press, which assumes tens of millions of dollars of casino licensing fees will be available. And I think, for the reasons I just spoke about, if the stay is granted, it begins to introduce a risk that the licensing fees may not be collected even in fiscal year 2015 by the end of next year, as again, because we don't know what lies ahead of us on the Region A licensing path. A point not made in our papers on the public interest argument that I wanted to mention this morning was that there's a direct effect on the Commission's finances, I think, of a stay. That is, if you assume that an agreement would be reached with either of the Region A applicants if the Commission determines at least one of them is worthy of getting a license. If you assume an agreement is reached that is akin to the agreement that was entered into last week, the week before with MGM, as I understand it, that agreement called for a more or less immediate payment for Commission operating expenses that was made before the election, even if the award would be now after the granted the election. If the licensing payments are, if the licensing process is stopped now, there's no possibility of that sort of agreement being reached anytime soon. I'm looking down to skip things that others have already said. But on the interest of the voters, I think there's something else that deserves to be said. In general, there have been many commenters, both at this table and through the Commission's comment functions, that talk about getting more information to people. And I think that cannot be understated, the importance of that. The many questions have arisen during the course of this process. The law has been, in ways, being implemented for 2.5 years now. And with respect to the Region A license, questions have arisen. We list some of them in our papers on all sorts of topics. Are the revenue projections going to come to bear? Are the impacts going to be what they say they are? Are the applicants suitable? Who are the people who own land? Who is going to be involved in the process? All of these things are out there. They're pending. People have them in their minds, but they don't know what the Commission's answers are to those questions. Right or wrong, that is, whether the answers are right or wrong, or whether people will agree with them or not, I think, and they're making an assessment of the statute itself, they deserve to have those answers before them. And I'll close with just a brief word on the likelihood of success argument. I've gotten this far without saying anything about the prospects for the petition at the polls. Boston contends the polls are relevant because likelihood of success is part of the appropriate legal analysis as stated before, and along with the other commenters here, we disagree that that is the right legal analysis. But even if they got the legal standard correct and likelihood of success is proper, there's just no basis for concluding now that the initiative petition will succeed on the ballot in November. We were asked whether we'd hear anything about more recent polls than perhaps the 2-week-old ones that we cited in our papers, and this morning WBUR obliged, and it speaks also to the trend. They're reporting that their poll today shows 56% of the people of Massachusetts support retaining casinos, and 38% disapprove. And the trend that they found in their polls, conducted by one news organization or by one polling entity on behalf of one news organization, are all in the direction of continued support. March 2014, a 3-point difference: 46% support, 43% opposed to casino gaming. 2 months later, May 2014, 49% support, 39% opposed. A 10-point split.
That's 15 minutes. So if you'd wind up now, I'd be grateful. Thank you.
And today's poll that they're reporting, almost 20 points in favor of retaining casinos, 56 to 38.
Thank you very much.
Thank you.
Mr. Starr?
Thank you, Judge McHugh. Good morning, members of the Commission.
Morning.
As the Commission knows, my name is Tony Starr from the law firm of Mintz-Levin, and I represent Win Mass LLC. On behalf of Win Mass, thank you very much for the opportunity to appear today to address these important issues raised by the city's motion. For my purposes, I think that counsel before me has explained to you why the standard that the city has asked you to consider is inappropriate. I share that from a legal point of view, but for purposes of our presentation today, I'll accept their arguments as being the right standard for purposes of the discussion, and then I'll take you through each of the 4 of the arguments that the city advances and explain to you why each of those 4, as suggested by the city, fails. Let's take the first argument of the city. I'm reading directly from their motion now. The city will have to devote considerable costs, including legal fees, as well as time and other resources from City Hall to negotiate and/or arbitrate agreements with the applicants. Not true. The statutory negotiation period with Win ended on June 25th. It had been extended from June 16th to the 25th by 9 days to help support the ongoing negotiations by use of the flex. But that negotiation period has ended. While Wynn would welcome the chance to reach a surrounding community agreement consensually with the city, that negotiation period has ended. There is no more cost there. We are now into the phase of arbitration. As has been said before, on behalf of my client, I sent notice of arbitration last Thursday, which starts the 5-day window in which the parties are to select arbitrators and exchange their BAFOs. The arbitration process, which you have set out in your regulatory proceedings, and which you know I have now participated in twice in the last 6 weeks, so I know quite well that process with Chelsea and Somerville. It is expeditious, it is efficient, and it is relatively inexpensive. It will start in just a few days. If you restart the clock, we'll be in arbitration in a matter of days. It must be complete by your rules in 20 days. If Boston agrees with Wynn on a single arbitrator, Wynn pays for the entire cost of that arbitrator. If the parties are unable to agree on a single arbitrator, and there's a 3-arbitrator panel, Wynn pays 2/3 of the expense of the arbitrator. The 20-day period that you've set up, realistically, would only allow for 3 or 4 days of hearings. In both cases with Chelsea and Somerville, that's exactly what we had. 3 days of hearings, full days of hearings, and an opportunity for closing arguments. It is not a costly proceeding. And Boston, as you know, has an Office of Gaming Accountability. I would suggest to the Commission, after at least 10 months, since early September of 2013, when the issue of Boston as a surrounding community first came before this Commission, they are well prepared to present whatever evidence they have to an arbitrator or a panel in support of their position on impacts. By design, it is not a costly process. And by the way, as has been said before, contrary to Boston's claim, a 4-month delay does harm to the other stakeholders. In the case of Wynn, there are commitments to employees, to consultants, land acquisition option payments, possible renegotiation of options, and so forth. And as has been said before, no opportunity for Wynn to get those expenses back. And by the way, the harm to Boston of participating in the regulatory mandated arbitration process is not only relatively minimal, it's not irreparable harm. It's economic harm, which, as the courts have held repeatedly, is not irreparable harm. And it's their standard. That's what they've asked to be judged by. Their second argument: a stay is in the public interest because any action the city takes with respect to the ongoing negotiation and arbitration process may unfairly impact voters. Not true. And by the way, the city provides absolutely no explanation or support for this conclusory statement. Wynn would suggest that the city's position in that regard makes no sense. Providing more certainty to the voters as to which applicant, if either, will receive the license, where the casino will be located, what the economic benefits and mitigation payments will be, will help but not hurt voters. I turned the clock back 225 years to Thomas Jefferson. Here's what he said: whenever the people are well informed, they can be trusted with their own government. It's not just 225 years ago. On July 1st, Dr. Clyde Barrow, a name I believe you're familiar with, director of the Center for Policy Analysis, released a statement. And I'd like to read a couple of comments from that. He said that even though the Massachusetts licensing processing has been slow, the Commission succeeded in encouraging and spurring competition regionally and statewide during the past 3 years. And I quote now: casino developers came to Massachusetts because the Commission was aggressive, vocal, and determined to create a truly competitive process. The main goal of the Massachusetts Expanded Gaming Act was to spur economic growth statewide and in each of the state's major regions, and the Commission recognized that only a truly competitive process would achieve those results. But Barrow cautioned that with a November referendum now scheduled, the entire process and its success rests on how the Commission decides the Greater Boston Region A license, as well as its willingness to more aggressively promote a Southeastern Massachusetts Region Street commercial license, or continue to hold the Mashpee Wampanoag Tribes Casino interests as privileged. Barrow said that, and here's what's the important part of this quote, "The time has come for the Commission to make final decision in Greater Boston, Region A, and in Southeastern Massachusetts, Region C, that fulfill the intent of the gaming law by creating thousands of new jobs in up to 150 occupations at all levels of the skill matrix, and that require employees at all levels of educational attainment." Barrow observed, "For the last 3 years, the public discussion has been a lopsided monologue about mitigation payments, land deals, litigation, and background investigations, while continual delays in the process have shifted the economic benefits from casino gaming into the background of an indeterminate future. The Commission should make its 2 remaining licensing decisions before the November referendum, because voters should be armed with the knowledge to cast a fully informed vote, no matter how they now intend to vote." Wynn agrees with Dr. Barrow. Voters would benefit from more knowledge about where the Region A casino will be located and what the economic benefits will be. And a better informed electorate surely serves the public interest. To the contrary, the public interest is certainly not served by treating Boston differently from the many other surrounding communities, I believe nearly 30 in number, who have participated in the surrounding community process. It is not in the public interest to treat Boston differently from those communities. The third argument the city advances: recent reports have shown that support for the expanded gambling has waned since the enactment of the Enhanced Gaming Act, making it likely that expanded gaming will be repealed. I see no merit to that argument. The Commission has a statutory duty to proceed forward and fulfill its statutory mandate. Boston's suggestion that interim polling results should inform the Commission on how and when it should perform its duly authorized duties and obligations is totally inappropriate. The idea that the Commission should suspend its work that is authorized by statute and regulation to do because of unspecified recent reports is frivolous. And I might add, as I think Mr. Barnett mentioned, just today, WBUR poll results, and I brought the article, were released. And exactly as Mr. Barnett said, a week after the state's highest court cleared the way for a repeal of the casino law to go on the November ballot, a new WBUR poll suggests that gambling proponents would begin such a highly anticipated voter initiative with clear popular support. 56% of respondents said they approve of locating casinos in Massachusetts, while 38% said they disapprove. Let's go to their fourth argument. They write, "Other courts that have considered the merits of granting stays in the face of upcoming citizens' referendum have found in favor of protecting the voters' rights and suspending intervening action that potentially could be rendered moot or reversed by the outcome at the ballot box." Again, not true. Unable to find any support for the position in Massachusetts, they go 3,000 miles away to California, and they provide you with 2 decisions from California. Mr. Barnett, in his letter, and Wynn in the opposition memo that I submitted, pointed out to you why both of those California cases are simply not on point. In the first case, the Assembly versus Duke-Majian case, the court granted the plaintiff's motion to stay because the California Constitution expressly required it. Not the case here. The second case they cited, Lindelli versus Town of San Anselmo, the court granted the stay because the stay provision appeared in the Elections Code, which was the underlying legislation. The stay provision there stated, and I quote, "When an ordinance is the subject of a referendum petition, it shall not take effect until the majority of voters voting on the referendum approve the ordinance." Again, not the case here. As more fully explained in our memo, as eloquently explained by Attorney Barnett today, there is a difference in the Massachusetts Constitution between a referendum petition and initiative petition. This is an initiative petition. There is no request in the initiative petition for a stay, the city is essentially asking you to do something which the petition itself didn't ask for. We believe the request in that regard is inconsistent with the Massachusetts Constitution. For the reasons that I've just shared with you, for the reasons advanced today by counsel for the Mohegan Sun, Revere, and Everett, the reasons set forth in our opposition memo, and the thoughtful analysis in particular provided by the City of Everett in its July 1 comment letter to you and at today's hearings, Wynn believes that Boston's motion should be denied. It should be denied today. The surrounding community arbitration between Wynn and Boston should proceed, and the Commission should continue its good and hard work on the Region A Category 1 gaming license. Thank you for the time today.
All right, Mr. Starr, thank you. Now, I know that I certainly have some questions, and I know my colleagues have some questions, but Mr. O'Flaherty, you had some unused time, so I'm going to give you 5 minutes more. This isn't stoppage time or extended time, it's unused time. And if you'd like to take advantage of that 5 minutes, I'll give that to you before we begin with some questions.
Thank you very much, Mr. Chairman, and we certainly will. And Attorney Tom Frangillo would like to make a few points if that's acceptable to you, Mr. Chairman.
Mr. Frangillo.
Thank you. What we've just heard from the City of Everett, the City of Revere, and the two applicants is that they are afraid of democracy. The Supreme Judicial Court has made it clear that the voters will decide this issue in 120 days, 4 months. If it were 30 days, would they be sitting at the table? If it were 60, would they be saying that they are irreparably harmed? If it were 90, would they actually be here making these arguments? And the answer is no. What they're trying to do, they want you to issue a license to influence the result of the vote. And the Supreme Judicial Court has said, this is a decision of the voters. The status of the proceedings should be halted. The voters have plenty of information right now. Do we reasonably or credibly think that the voters in the Commonwealth of Massachusetts don't know what comprises the Everett plan that Wynn is proposing, or the Mohegan Sun one at Suffolk Downs? There's been public hearings, there's transcripts, they've been televised. There's plenty of information for the voters to engage in educated voting on the issue. These applicants in these cities don't want democracy to take place with the status quo. It's a red herring for Everett and Revere to come up here before you and to talk about the monetary loss that they're going to suffer with a 4-month delay. That assumes they're getting a license. They're not going to lose a penny unless a license is issued. If the voters come out and say, we repeal the law, then where is their $8 million of lost taxation money? Or workers not getting jobs, or all the other maladies that they claim are going to happen over the next 120 days? Nothing. In reimbursement to the City of Boston, where does that come from? As I understand it, there is a gaming revenue fund under Section 59 of the statute, and under Section 61, there is a community mitigation fund, all of which are premised on a license being issued and the Commonwealth getting taxes based on revenues generated, which all may be moot in 120 days. The lawyers have misstated the test for irreparable injury. They all know that it isn't just a question if money were there to compensate the moving party, that the moving party therefore has no irreparable harm. The issue is there an adequate remedy at law? And there is no money here to reimburse Boston. If there is a repeal, who's going to pay Boston? Are they going to? Is Wynn going to write a check to Boston and say, by the way, that expensive arbitration, which has been grossly understated as to what it's going to cost the City of Boston if it participates in it, that we'll gladly foot the bill for your experts that are going to talk about the impact of this casino on a $100 million transportation renovation of Sullivan Square, are they going to pay for our consultants and our experts and the lawyers to prepare those arguments? And the answer is they have no intention to do that. There is no credible reimbursement to the city, and there's absolutely no harm to them to wait 120 days. It's no different than if they waited 90, 60, or 30. They have no credible argument to let democracy take place and to let the voters have their say. So the concept that the city of Boston costs are minimal is just factually wrong, or it represents a fundamental misunderstanding of what these applicants think would happen at an arbitration on behalf of the city. There is no compensation for Boston. Boston is the largest municipality by far in the Commonwealth of Massachusetts. It is the capital. It is the city that will be the most impacted, even more so than Everett and Revere, by the development of a casino. It has the most voters, and those voters deserve a right to have an unimpeded path that is uninfluenced by the spending of millions of dollars or the issuance of a license to decide what they think is proper. And
Right,
it
Mr.
puts
Frangillo,
no
you're-
harm on anyone to wait
5
that
minutes is up.
period.
Thank you very much, sir. All right, we've heard now from each of those who would be most directly impacted by this. Questions from the commissioners?
Yeah, I do.
Mr. Zuniga?
Mr. Frangillo or Attorney Flaherty, are you familiar with some of the arbitration results from other surrounding communities and the best and final offers that have been rendered to date?
We don't have, yes, however, we don't feel that they have any impact on our position.
Well, I'm getting to the point about reimbursement of reasonable attorney's fees. Because as Attorney Silverstein alluded to, the best and final offers generally contained the reimbursement after the arbitration process of reasonable attorney's fees spent by the city.
While we understand the issue of attorney's fees, I think and that is certainly an argument that has been put forth in the documents that we've submitted to you in the form of our motion. However, part 2 of that, which was not referenced by any of my colleagues up here, is that the city feels the irreparable harm also applies to the voters, and that the voters should have an unimpeded path, as Attorney Frangillo suggested, to having a vote in November that is undecided by anybody prior. So the irreparable harm also not only involves the monetary issues, but also the irreparable harm to the voters, because in essence they could be influenced by any change that takes place in terms of the licensing process, whether you grant it or do not grant it. That could influence voters. In particular, it could influence voters in East Boston or Charlestown. And part of our argument is that that will irreparably harm the right of the people to vote, as was explicitly expressed in the Abdow decision by the Supreme Judicial Court.
How does more information does irreparable harm? More information, specifically I'm talking about the results of a surrounding community agreement, if this process is let go forward.
I don't understand the question.
I don't know what you mean by irreparable harm to the voters in the scenario where either a surrounding community agreement is reached or an arbitration result is also reached that then is put forth to the voters.
I think, Commissioner, to answer your question, it's a very common sense answer. The average person who is aware that the Supreme Judicial Court has just asked the people to vote on whether casino gaming should proceed in Massachusetts or not is confused by whether or not a licensing process granting that right should take place when in 120 days the people will be making a decision. I have had it referred to me by one constituent as putting the cart in front of the horse.
We've heard that before.
So to answer your question, I think the average person would like to know why the Commonwealth of Massachusetts, through its administrative agency appointed by the legislature, is still engaged in a process given the gravity of the Abdow decision, the unprecedented situation that the Commonwealth is in given the Abdow decision, and your process that you've engaged in for quite some time. And the average person, I believe, common sense would dictate, would want to see a vote in November before any of these proceedings go on, regardless of the statutory mandate or not.
Even though it's the law currently.
The law on casino gaming will be decided in November. The
Well,
law
it is-
currently, and I understand, and that is the trepidation that the city of Boston has had, even in participating this morning, because we understand your mandate, we understand statutorily what you're trying to achieve, and in fairness to us, it puts us in a very difficult position if we're assuming that our motion will be accepted and viewed impartially and decided impartially. And hopefully you'll understand that trepidation that we are facing given the knowledge that you are pursuing your statutory objectives. However, it's our feeling, based on the Abdow decision, that that supersedes what you have in front of you. That the will of the people to decide this issue in November, at this particular point, in uncharted waters, first impression for the Commonwealth, requires a halt, requires the people to vote, and if they so choose to go forward, then we proceed. Nobody is harmed if we do that. The people of Everett have had their vote. The people of Revere have had their vote. There are host community agreements in place. The people will not be harmed in those respective areas. The Commonwealth will not be harmed if a mere 120 days, a timeout is taken, and we see what the people have to say in November.
Let me follow up on that. Let me come back to Commissioner Zuniga's question. How are the people adversely impacted by knowing what the terms of a surrounding community agreement are? He asked the question of how does more information harm the voter and voting process? The impact of allowing the surrounding community process to go forward now would be to have a surrounding community agreement, either by agreement or by arbitration, shortly, and well before the election took place. So people would no longer, insofar as surrounding community agreements are concerned, be dealing with an abstraction. They'd be dealing with something that was concrete. How does that hurt the process?
Well, let me be speculative, if I may, Mr. Chairman. Let's assume that the city of Boston were to arrive at a surrounding community agreement with one of the proponents.
Right.
Perhaps there could be some constituents in the city that would view that as being favorable to the city,
Right.
and therefore might influence their vote in November.
And where's the harm from that?
Well, the harm should be, as far as we're concerned, that the voter should make their own decisions, that the Abdow decision has asked this to be put in front of the people in November, and the proponents certainly, as well as the opposition that are out there, will engage in a process this November. That's going to be plenty of information for the voters.
Well, I understand that, Mr. Flaherty, and I'm not trying to cross-examine you. I'm just trying to understand, and I'm not sure I understand how giving voters an additional piece of information. Surely, as you said, those who have carefully followed this process know what the proposals are. But how does helping them understand by executing a surrounding community agreement which has the terms of the relationship, the terms of the traffic mitigation, the terms of the monies that flow to the city, how does that harm them when they go to the polls? Some may say, this is great, this changes my mind, I think this is a good idea. Some may say, this is a lousy surrounding community agreement. I was in favor of this thing generally, but I don't like this, so I'm going to vote against it. In either way, it's additional information for people to make a judgment about.
It could be also negative information.
Absolutely.
So I think it's speculative to decide how the voter is going to view that particular question that you're asking me with all due respect, Mr. Chairman. It's up to the individual voter to answer that very question themselves in November.
Yes, sir, absolutely. But I guess I've made my point. Let's go to the licensing decision. The arrangement that was made with MGM was not a license issuance. It was a license designation. There were contingencies. But I ask you the same question. How does letting the voters of the city and of the region, the surrounding communities, because others are impacted by whatever goes on in Revere and Everett. How does letting the regional voters and the city voters know what the shape of the and location of the gaming establishment is going to be, how does that harm them? And let me give one other, I don't make this too windy a question, but everybody knows what the proposals are with respect to the two applicants. Nobody knows at the moment, because frankly the commission doesn't know, what the conditions are. So people can look at the proposals and say, this is going to be a mess in one way or another. But by the time the commission gets finished, it may not be a mess. One would hope that it wouldn't be a mess, and people would have that information. Mess or not, they would know. Now, I do put a question mark there.
Okay.
If a license is issued, the voters know who got the license.
Right?
And there can be tremendous pressure applied by those who are in favor of the license, unions, workers, whoever it is that says, you're going to take my job for me if you don't vote in favor of this. And it's improper. The court right now has said it's up to the voters to vote. And for us to move forward into basically take the ball over the goal line and say, Everett wins or Revere wins, creates maybe a huge disincentive for people who lost to stay home that would otherwise vote, and also creates a huge incentive for the winning party to go out and bang on doors and make a lot of noise about what the impact is going to be because a license has already been granted. That you're going to be taking food off my table. I've got a job there. I've been promised this. And right now, our court has said people have the right to vote. There is no reason at all to issue a license before this vote.
Well, I know, I hear.
There's no compelling reason to do it.
I know that's your position, Mr. Frenchel. I'm just trying to ask questions so I can understand it better. If a license is designated, and as I say, it's unlikely that a license would actually issue before the referendum, but a license is designated, then those who are not in favor of that license, in fact, view it as a bad thing, would be energized to go out and vote against the whole deal. They would be energized to go out and vote in favor of the initiative. Likewise, those who think this is really good and this is a good thing would be energized to go out and vote against the initiative for that very reason, would they not? Doesn't it balance out? I don't see how it skews it. It may energize voters, but I don't see how it skews voters.
If no license is issued, people are going to vote based on the information available to them right now.
Yes, sir, and that's a possibility that may come out of the commission's process.
Right.
But that's a possibility.
And there are different variables at play if
Right.
no license is issued.
Right.
I think we all would acknowledge that.
Right. Let me ask another question, though, if I might, and I've taken this over, but I'll relinquish in a minute. This is for Mr. O'Flaherty. Your June 26th letter says, and I'm quoting in part now from the second paragraph, if you have it in front of you. If not, I'll quote it accurately. If casino gambling is prohibited, the issue of Category 1 gaming licenses in Region A will be moot. If it is allowed, I remain hopeful that the citizens of Boston will be able to vote on whether or not they approve of the pending casino proposals in Region A. What's that second sentence mean?
I believe what it states, Mr. Chairman.
Okay, let me sharpen my question. If the initiative is rejected by the voters, is it the city's intention to find a way to have a vote in Boston before any license issues?
Mr. Chairman, we're not stipulating whether we're a surrounding community or a host community. As you well know, it is Boston's position that on both proponents, dealing with both proponents, that Boston is a host community. As the law requires, the existing law, if we are designated a host community, whether by this commission or by another court in another jurisdiction, then if it is a host community, a vote is required in that particular section of the city.
Okay, so I think you did, I think I understand the position now. So the bottom line here is that if the, and really I'm trying to find out what the end game is, because I think everybody would benefit by knowing what the end game is. The commission would, the applicants would, the citizens of Boston. I can't speak for them, though I am one. If the initiative is rejected, then the city will still claim host community status and seek to have a vote.
That remains to be determined, Mr. Chairman.
My concern here then with the request for a stay is amplified, because it seems to me that the position of the city is that if the initiative fails, we're going to be back where we were last December when we started with the city's contention that it was a host community. And insofar as the commission is concerned, that train has left the station. The commission has made its decision. I recognize that the city disagrees with it. I understand that. But insofar as the commission's concerned, that decision's been made. It's not going to change. And so to say today that we wait 4 months and then we go back to where we were last December and try to figure out how, where, in what forum, under what circumstances we can find a vote for the city means that we're facing a delay of untold lengths of time.
That is assuming that that would be our position at that time, Mr. Chairman. And to answer, if I may, some of
Surely.
the representations that you've made.
I'm sorry?
If I may answer some of the representations that you've
Yes,
made.
sir, surely.
This commission itself has indicated that we are in an atmosphere of uncertainty. So when you talk about going back in time to a previous time, I think what you're leaving out of the equation, respectfully, is the Abdal decision. That has put this commission, it has put this Commonwealth in uncharted waters, uncharted territory. And it's part of your statutory ability to recognize that and to decide whether or not this commission and your process and what you are engaged in, given the vote in November, requires you to continue or requires a pause of a mere 120 days so that the voters can decide whether or not what your original statutory obligations are then going to continue or not.
Right.
A stay means the status quo, Mr. Chairman. Nothing changes. There will be no harm to Ever to Revere. As I've indicated, their vote will still be good. The host agreements and the status still applies. In terms of the representations that there will be harm to the Commonwealth, the Mass Gaming Commission itself, or the proponents, if there is a delay until November, if one were to argue that the state is being deprived of money here from the licensing fees, it's only a delay of a couple of months. The monies are available in the rainy day fund. If the Commonwealth needs that money, they can dip into it. If licensing goes forward and casino gaming proceeds, they will be paid their money back. So I respectfully suggest that the SJC's rationale to have a vote is, or should be viewed as a condition precedent to what you're doing here in these proceedings, respectfully.
All right, I understand your position, Mr. O'Flaherty. Thank you. Let me ask you about one other letter on a related but not directly connected topic, and that's your letter of June 30, 2014. And the last paragraph of that letter has to do with the arbitration proceedings. The last paragraph of that letter, this is a letter to set the stage that came in response to Mr. Starr's letter to you saying that arbitration was commencing and that he was moving forward. The specific details are not relevant. And he sent that pursuant to the Commission's regulations and timelines embodied in those regulations. The last paragraph of your letter says, in light of its pending motion to stay, that's this motion that we're talking about here today, the city considers all negotiations and arbitrations deadlines with respect to potential agreements with WinMass LLC and Mohegan Sun Massachusetts LLC to be suspended until the commission renders its decision. Pending the outcome of the city's motion, the city presently does not intend to participate in negotiation and arbitration regarding the surrounding community issues. How did things get suspended?
Respectfully, Mr. Chairman, there was a unilateral decision on our behalf, given the nature of the proceedings that we've participated in thus far, how respectfully we feel the city of Boston has been treated thus far, and respectfully maintaining and asserting potential rights and privileges that we will exert at a later time.
So the city simply decided that the regulations didn't apply anymore.
Given the enormous change in circumstances, given the Abdow decision, we respectfully hope that you agree with our rationale that there should be a suspension of discussions, a suspension of arbitration, so that the fundamental right to vote can be exercised under Article 48 of the people of the Commonwealth of Massachusetts.
I hear you, Mr. O'Flaherty, and I understand that your desire, understandably, is that we agree with you. But I'm concerned about the position that the city is taking, that it has the ability to make unilateral decisions that suspend the regulations that apply to every other municipality and every other applicant in the Commonwealth. This is reminiscent, with all due respect, and I do say this respectfully because I want this to be a conversation, not a confrontation. It's reminiscent of the city's declaration that it was a host community, another unilateral declaration. And I'm troubled by the thought that regardless of what the voters do in November, the commission and the citizens of surrounding communities and the citizens of Boston are going to be faced with a situation in which the city will then make up its mind as to what it's going to do. Maybe it doesn't want these things under any circumstances, and unilaterally proceed in an effort to make whatever desire it has at the moment come true.
Mr. Chairman, respectfully, I suggest that that's speculative, that that is not our position at the current moment.
Right.
Our position at the current moment, and we hope that you'll agree with us, because we truly feel that the people, the average person in Massachusetts agrees with us in our position, that this issue should be stayed until the people have voted on this matter. At that particular point, if the people decide that this is going forward, then the city of Boston will have a position. If the people reject this and decide that it should not go forward, then the city of Boston will have a position. To engage, and I say this respectfully, Mr. Chairman, with back and forth speculation on what that means for us, as I said earlier, it's putting the cart in front of the horse.
Well, I'm going to close this. I don't want to prolong it, but I remain concerned, and I say this respectfully too, that in assessing the desirability, the utility of a stay, the commission look down the road and see what's ahead of it. And the only way it can make predictions in terms of its regulatory responsibilities looking down the road is to look in the rearview mirror and see what's gone on thus far. And so it's for that reason that I raised that question.
I understand, and Mr. Chairman, to aid you in that thought process and your colleagues, I think it's fair from our position that, as I indicated earlier, that once the people decide this issue in November, it can change thoughts that currently exist. It can change current methods and processes. There's a whole lot that's riding on that vote in November.
Right.
And respectfully, it's our position that the matter should be stayed until that decision has been made.
That point I clearly understand. All right. Commissioner Cameron.
I had one question for Mr. O'Flaherty. You're asking us to, you're telling us that your constituents agree with you that they would like to see this matter stayed, and I'm just asking you to clarify that, because one matter that I too am struggling with your argument about the voters and how more information is not helpful to them. One thing, I don't want to repeat what my colleagues have said, but one issue, we read all the comments, and in this particular matter, the City of Boston, the residents are never shy to come out to hearings and speak to us, which we appreciate, or to make comments, to write to us. And in this particular request for comment, we received over 300 comments, all of them in support of moving forward with the process. One undecided that I read. One was not sure how we should proceed. Everyone else was in favor of us moving forward. Last week alone, we had hearings in both Revere and in Everett, in which many citizens from Boston came to testify. Charlestown in particular wanted more information. They wanted to know more about traffic mitigation. They wanted more information in order to be either accepting or non-accepting of the project. You know, that's the kind of information we could provide by proceeding with the licensing process. Well, just, you made the assertion that your constituents agreed with you, and I'm just not seeing evidence of it.
Madam Commissioner, when I was referring to constituents, I wasn't referring to my constituents. I was merely referring to my trip to a local coffee shop, where in my previous life, I was an elected official. 5 gentlemen in particular had every problem in this world solved that sat in that corner of the coffee shop. And the other morning, when I went in for my coffee, I was called over by those 5 gentlemen. All 5 of them, by the way, casino advocates and supporters who gave me a very hard time in my previous career on my particular issues on these matters. And all 5 of them agreed. All 5 of them agreed that it made sense that there should be a stay in the proceedings until the people vote. These are average working men. No fancy degrees or titles, just average guys. Most of them retired. And that is what I base my representations on. To comment further on specifically how my constituents feel, that's outside of my bailiwick now that I'm no longer an elected official. But one thing I can say is the mayor of the city of Boston has been consistent throughout this entire process, given his legislative career, his votes on these particular matters, but assuming the role of mayor, he has been consistent that the people in East Boston and Charlestown should have a right to vote on this matter. The fact that the Supreme Judicial Court of Massachusetts has given that right in the Abdow decision to the people of the entire Commonwealth of Massachusetts has been a sigh of relief that the people will finally have a vote on this matter, not only in East Boston and Charlestown, but in all the 350 other municipalities in our Commonwealth.
But doesn't reaching a surrounding community agreement give those constituents that luxury? If you reached a surrounding community agreement in one of the areas and were forced into arbitration or went into arbitration, that whatever the result of that would inform those very voters for whom you are advocating a vote.
Perhaps some, Commissioner, but perhaps maybe not with others. It is pure speculation. That speculation will be resolved with that vote in November.
All right. Anything further?
I have a couple questions for the city. Just a few, and they're somewhat not connected, but some information I'm curious about. The city, you point to extenuating cost of time, money, and effort by the city. Have you been able to even come up with a rough estimate to help give us an idea what the costs are that the city would have to bear?
I can't give you an exact estimate today, but I can say the word substantial would apply.
Okay. Was there any thought or discussion within City Hall is to suggesting that this commission stay its activities during the proceedings of the Abdow case? I believe the arguments were heard back in May, and obviously the decision rendered in June. I'm probably one of the minority in the room who's not a lawyer, but is there a legal explanation from the city as to, why not ask for the stay until that case was decided?
Any representations that would have been made by the city at that particular time would, again, and I hate to keep using this word, and I do apologize, pure speculation.
Two other quick questions. And please, I'm not familiar with the operations of the city of Boston, but from time to time I do hear about proposals being issued by the BRA, for instance, to redevelop a certain parcel of property. And I'm assuming because of the attractiveness of an investment in the city in Boston, the potential return on that investment, you get multiple applicants. Is there somewhat of a business-friendly approach that it might be helpful to, as we've learned, as we've tried to move as fast as we can, try to select a winner, a bidder, so that, one, the project can proceed, but you also, in essence, give the other bidders the opportunity to move on? Is that not a position that the commission should also subscribe to, that if we make a decision, we give one other venture who wasn't the lucky bidder the chance to move on and continue their other business pursuits instead of holding them up over this additional 4-month period?
I think that would be a factor for you and your colleagues to consider, Commissioner. For the city, we recognize that the proponents here, as I referred to them earlier, and I did not mean to do that disrespectfully, but they are well-heeled entities. They make a lot of money. They understand the process that they're engaged in. In fact, some of them have gone into other communities, have left other communities, have stayed in other communities. They're aware of the process, they're aware of the costs, they're aware of the investment, and they're aware of the loss of that investment if such a scenario as you described occurs.
Is there any suggestion today that if you're asking us to stay our process, that our applicants should suspend a number of the activities that they're proceeding with, such as filing with the Environmental Affairs Secretariat a final environmental impact report?
Nothing that we're suggesting would prohibit the proponents from continuing the process. All we're asking is that you and your colleagues stay your judgment in this matter until the Abdow decision and the vote that's required because of that decision takes place. Nothing that we're asking for would prohibit the proponents from continuing to engage in, from a business perspective, whatever they need to do in anticipation of that, including campaigning, I imagine, very strongly on that vote in November.
Okay. Thank you.
All right, any further questions? All right. Well, thank you all very much
Thank you,
for those helpful presentations. All right. Let's turn to a discussion. Who wants to start?
Let me mention something that was a little bit on my mind. There is a principle in the Gaming Act, contained in the Gaming Act, relative to host communities that puts the matter to the voters, in which as the legislation actually is very specific, it's not the question as to whether to have casinos or not. It is the question as to whether the voter approves for a casino in a particular location. And the Gaming Act also requires that the host community agreement be posted on a website prior to the call for the election, which has to happen within 60 to 90 days. So the principle, as I read it, is that the voter in the host community who is going to go vote as to whether they want a casino or not will be informed by the host community agreement. The financial benefits, the location, the mitigation monies, the monies that go to the different funds, how those funds are going to be used, et cetera, et cetera. The situation that we find ourselves with in Boston at this juncture, given all the complications about implementing the law that were referenced earlier, in my opinion, almost mirror that host community principle, in which if a surrounding community agreement is reached, either negotiated or arbitrated, those surrounding community agreements, the terms of those agreements will be available to everybody, in this case, for actually a period almost like 60 to 90 days. Just if we assume that arbitration commences today, and we can talk about that later, if the clock is reset, etc., the latest of a binding arbitration result will be a month from now, which would be towards early August. And with a November petition or election, that would be almost 90 days, which is exactly the same as was provided for to host communities. So when Boston has asked about both the notion that they are a host community, and I know we've talked about that. I thought we had solved that issue a while ago. This would be unique, in my view, for the citizens of Boston and the region, and of course the Commonwealth, to benefit from the 90 days that is afforded to the voters in terms of understanding the surrounding community agreement that is either reached or arrived to because of arbitration. So I'm looking forward to hear more points about it, but I don't see how the public interest is not served by this continuing, and that's a double negative, I realize. I think the public interest is served by continuing with the proceedings, because we will likely arrive to a surrounding community or two surrounding community agreements with enough time for the voters to make a judgment as to what they think.
Well, that goes into the more information is better.
Yes.
Overall. And that's just a particular example. And of course, it's not a binding vote. And that, of course, is the difference. But that's basically another aspect of more information is better.
Right.
And
Right.
It's hard to understand how more information would adversely impact.
Right.
Right. Okay. I understand.
There's another element and comparison to that was talked a little bit about here in terms of probability of something happening or not, and regulations applying to a lot of other communities. There's a number of surrounding communities, and I remember Category 2 surrounding communities that went through the process of negotiating a surrounding community agreement, where the chances of getting effectively an operation nearby were less than 50%. I would argue they were 33%. We had 3 applicants in the case of Category 2. I would argue that it were even less than 33% because we were not compelled, we're not required to issue a license, for example. But because of the significance of such a development, going through the process regardless of the chances of that coming to fruition was also a very important principle is also a very important principle in the Gaming Act, because prior to the award of the license, those surrounding community agreements need to be reached in place, because the award of the license really changes the dynamics of how those negotiations could eventually come to fruition.
All right, other thoughts? Commissioner Cameron?
Yes, of all of the arguments Boston has made, the one that was most compelling to me was harm to a voter. And I just don't see how more information is harmful to any voter in the Commonwealth. In fact, I really see a benefit to more information. That's traffic mitigation, that's surrounding community agreements, that's listening to presentations about each aspect of this proposal. I've seen how beneficial it was in our other award decisions. So that's the issue that gave me pause, and it's the issue that I just, after listening to everyone, and all of the folks around the Commonwealth, I believe that more information is helpful to every voter, and I see that issue as the most important one we're looking at here today.
Commissioner Stebbins?
I also join with you in talking about more information is better. If you can draw comparisons with the state of Ohio when expanded gaming was introduced in Ohio, for several years they tried to pass referendums that weren't site-specific, but just asked voters, do you support expanded gaming in the state of Ohio? And all of those went down to defeat. And I'm not suggesting this is any type of forecast for what may or may not happen in November. Proponents will argue, and I think rightly so, when they actually began to define where the locations were, almost by geographical latitude and longitude, where the building was going to go, expanded gaming passed. Some would argue that because voters knew it potentially wasn't going to be in their backyard, but was going to actually be in Community A, it was more information for them to have when they approached the voting booth. I think for that reason, moving ahead with our evaluation process, I think is critical to the voters. Secondly, I think, moving ahead with our process, again, because we have two very competitive applicants, we have two applicants that have business ventures elsewhere, I think we do them a favor by, allowing them to complete this process with us if they aren't selected, and allowing them to continue on. I understand that the applicants are probably well-heeled financially, but they have shareholders who would probably encourage them to find every way to spend $1 less if they had that opportunity. So I don't see any reason that both voters and our applicants don't benefit from moving this process ahead.
Well, I have a number of thoughts that emerged out of listening to the presentations this morning and reading the submissions last night. The first is a sort of a constitutional overlay, and I don't want to spend much time on it because it's not dispositive. But there is, under the Article 48, the constitutional provision, there is a provision for stopping the existence and efficacy of existing legislation, and that is the referendum process. And that process is designed to stop legislation at the outset before it gets underway if certain criteria are met, and let the people take a look at it and decide whether they want that legislation to go forward or not. That's not the process we're using now. We're in an initiative process which has a very different track and doesn't have a stay provision. What does that mean? Does that determine the outcome? It doesn't. But it gives a sort of constitutional overlay, the way the founders, those who amended the founders' work, thought government ought to work, and that is, if you can stop legislation's efficacy and operation before it gets underway, all well and good. Have a vote on it before it moves forward. But otherwise, the legislation presumptively moves forward, the operation's in effect, and you carry it out until the people say no. And so that's sort of a backdrop against which I look at the city's request. Doesn't mean that we're prohibited from giving it, but it does inform the kind of overall social order, for me at least, that we ought to think about before as we make that decision. The second thing is that we have a series of regulations and a series of timelines and a series of steps that we've laid out in an effort to make this thing work. We've pushed those back, to be sure, once before at the request of the city, actually at the intervention of the city. But we also have a procedure for requesting waivers. The city hasn't asked for a waiver. It's just declared that it's not going to proceed with the outlines of our regulations pending our decision on this motion. In my view, the conditions for a waiver, the unasked for waiver, aren't met. And it's important to consider the second, for me at least, the second of those conditions, which is the grant of the request for a waiver won't interfere with the Commission's abilities to fulfill its duties. Those duties include not only the City of Boston, they include Region A and they include Region C. We've already taken care of Region B, we've taken care of the slots parlor. And we've set up these current deadlines for Region A in part so that the unsuccessful applicant in Region A will have an opportunity to participate in the Region C process, if it wishes to do so, as soon as it learns that it's not the successful bidder here. Whether or not they do is up to them. But we have to keep our eye on Region C, a region that we're having difficulty, quite frankly, in getting the market to respond to, because it's in Region C that the highest unemployment rate in the state exists. And the jobs and the promise of jobs in that region is an important part of our overall duties. And so the suspension of this process here has an impact on our ability to deal effectively with Region C. Region C has other problems and other issues and presents a complicated picture. But that's at least one aspect of that picture. We've talked about proceeding now will have a positive impact on the initiative process, and I agree with all of you about that. And in addition to that, I'm still at a loss as to what the end game is. I don't know what's going to happen if the initiative fails. I don't know. And I don't know because the city tells us today that it doesn't know. So it is hard to make judgments about the benefits of waiting when you don't know what is going to happen, at least with respect to one important participant, if one result of the initiative process occurs. In addition to that, it seems to me, far-fetched perhaps, but possible, one always hopes, the proceeding now may produce a result that's acceptable to the city. The Commission could decide to award neither license. That wouldn't please those sitting in the front row, but it might be acceptable to the city. The Commission might pick a candidate, an applicant, that it prefers, and then work out even after the process were finished. There's nothing prohibits working things out, smoothing off some rough edges. The Commission may make a provisional award, and a provisional award is all that's likely, and attach conditions that the city, and particularly the residents of a particular area, find acceptable. It meets the problems that they have, and so that is a particular a possibility. And as I said, proceeding now makes good sense, it seems to me, because we just don't know. It's good public policy because we just don't know what is going to happen from the city standpoint when this all comes to an end. We've designated the city as a surrounding community. I understand the city's disagreement with that. They've made that perfectly clear. But that designation isn't going to change. And if the city disagrees with that, then a legislative remedy is a logical way to deal with it. This is the procedure, this is the process, this is the laws. We understand it. Maybe the law wasn't designed for this kind of environment, these kinds of things. But there's some other remedy, but that's not going to change. And so, as I look at it overall, the November 4 vote creates one of two possible paths for the commission to go down. One is the path that exists if the initiative is successful, and that path is quite simple and quite short. We figure out how to gracefully fold up our tent and move away. The second path is to move forward swiftly with the licensing process to realize the potential that the legislature thought it was, with which the legislature believed it was filled. And it seems to me we need to plan for both tracks and adjust ourselves and our approach to this immediate question with both of those tracks in mind. So that's why I think that it is not appropriate at this stage to grant a stay, but instead it is appropriate to move forward and proceed with our licensing process. Any other thoughts of Commissioner Zuniga?
Yeah, no, I mean, I would agree with that. The one thing that I want to just emphasize for our audience is that in the case of proceeding, as we seem to be coalescing, more information will be better for the public interest, not to the outcome of the petition. I make no judgment as to whether we make no judgment, I suggest, as to whether more information will favor one applicant, either applicant, or the repeal, the eventual repeal. I am all for additional information. Will inform the voter. The voter will have will make their judgment with better information, and then the voter will decide what the outcome will be.
We don't always agree, frankly, but I do agree with both my colleagues, all three actually, and in their comments, as well as the path to move forward that Commissioner Q just outlined. I agree with all of his points, and the fact that moving forward with our licensing process is the prudent way to proceed for all of those reasons already stated.
All right. I think we're ready with that discussion for a motion. Would somebody care to make a motion?
Sure, I'll be happy to. I will move, Mr. Chair, that this commission deny the motion requested by the City of Boston for a stay in the licensing process and continue with our process stipulated in our regulations.
Is there a second to that?
Second.
Discussion? Further discussion?
I guess
Go ahead.
I'm going to discuss my own. We should also think about timing of our arbitration
Right.
proceedings because they were
I would like to deal with that separately.
separately. Yep.
Further discussion? All right. All in favor?
Aye.
The ayes have it unanimously. The motion is denied. All right, that does bring the question that Commissioner Zuniga addressed, and that is the question of how to proceed with the arbitrations. The arbitration deadline under our rules has arrived, and in fact, the process was started. Commissioner Zuniga, do you have some thoughts about where we go from
Yeah, I guess the deadline, if I'm, maybe we might need Council Blue to remind us of the dates, but there were a couple of flex 14 days that were different. But we are effectively today, for both applicants, we are no longer in the negotiation period. Is that a fair statement? And the arbitration proceedings for at least one of them would have started last Friday? Or? Right. They would be in the process of picking arbitrator, for which they had 5 days to do so. But those 5 days would be ending today?
For the Wynn and Boston negotiations, the 5th day is today. And for the Mohegan Sun and the City of Boston arbitration slash negotiations, that 5th day will be Monday.
Next Monday? Which includes a holiday in there. I would be in favor of, quote unquote, resetting the clock relative to that as of today on the picking the arbitrator for both applicants, with the understanding, of course, that even picking an arbitrator or commencing arbitration doesn't preclude the parties from reaching an agreement, a negotiated agreement, if they were already on their way to reaching one or not.
If we reset the clock to start the process today, really the whole process under whatever the regulation is, we'll find it. What do we do with the remaining Flex 14 time? We would not. What do we do with the remaining Flex 14?
And they have different days
Different
remaining,
days.
right? That's a wrinkle.
Right. It's not necessarily a reason not to reset the time, but it's something we have to take into account.
Well, the complicating factor is that our process is always determined, the deadline, arriving to a decision is always determined by the latest party to arrive at a decision, whether it's negotiated or arbitrated on.
So as of today, for Flex 14 days, the Wynn applicant has utilized 9 days, and the Mohegan Sun applicant has utilized 11 days. And not counting, obviously, the days of between the Boston motion and today, as those days were not voluntarily agreed to by both parties.
Well, we could. One option is to say we would reset the time to start today, and the regulation is 205 CMR 125.016, 01C. Reset the time to start that process today, and then, since we have to approve any further use of the Flex 14 time, announce that it's going to be only in the rarest of circumstances that we'll do that, and just plan not to allow any more Flex 14 time, unless there are extraordinary circumstances.
I would be fine with that.
Well, I know there were issues in other arbitration, and it is the summer, with an arbitrator having an issue around some other event or a vacation. I'm just wondering if, I have no issue with someone using that time that's allotted to them in the appropriate circumstance. I don't know that they have to be extraordinary.
Well, I've got my eye again on the goal line. And we've got a schedule now that is pretty tight, but pretty well thought out. We spent a lot of time thinking out, and that's what I was trying to assure that we could keep on track of. I really would, we just had a long and productive and productive morning about moving forward, and I would like to make certain that we create an environment where we move forward with certainty from this point forward, because.
I would agree with that. Other than, when I think of extraordinary, if there really is an issue beyond both parties' control, I would be, if it's reasonable, I would, there's only a few days left for each applicant.
So we have Flex 14 will approve if if it's really important.
Thank you, Commissioner.
All right. Well, then, under those circumstances, I would, that's what I'd be in favor of doing. I recognize that the city didn't ask for a waiver. I realize that it simply declared that the regulations were inoperative. But in order to avoid any possible confusion that arose out of that, it seems to me we just reset the clock by 5 days. We move forward, and we don't deviate from this point forward.
Commissioner, would it make sense for me to give the specific date by which the parties would have to submit their best and finals?
Surely, under that scenario.
Yeah, so
Yeah.
if the commission wants to reset the date, under our regulations, the parties have 5 working days to submit their best and finals and choose arbitrators.
Right.
Given the 4th of July holiday on Friday, that would bring us to next Thursday, July 10th.
Okay.
Oh, so it's a 5 working days.
5 working
Yes.
days.
Yeah.
Right.
Anything under 7 days is working days in our regulations. Yeah.
And we could if we do this, we could post on the website a revised schedule that would take into account those and dates and have everybody be aware of what the dates are. Okay. Well, there are
Do we-
reasons not to do that, but there are reasons to do it that I find more persuasive, and I think that eliminating any possible confusion that arose from the declaration would be a healthy thing. So I'd support that. Any other thoughts?
Do we need to move on
We
anything?
do.
or-
We do. We
Okay.
need to take a vote on that
I'm-
because it's an alteration of our regulations and time schedule.
I could gladly make a move if I get the actual regulation or deadline.
It's 205 CMR 125.016C.
Which provided for the beginning of arbitration proceedings as of June 27?
They were
Oh,
different dates.
different dates for different
Conversation of
applicants.
Flex
So
14.
we should keep it general.
We could just
Yeah.
have a motion that had the starting point for that set of regulations be
Today, yeah. So on that note, I will move, Mr. Chairman, that this commission amend its regulation contained in 125.016C to reflect the beginning of arbitration proceedings as of today.
Technically, today would be the last day of negotiations.
Okay.
So the first day of arbitration would begin July 3rd, first of the 5 days, bringing us till next
Okay.
Thursday, the 10th.
To amend the date contained in there to the conclusion of the negotiation proceedings as of today.
Okay.
Second.
Any further discussion? We're not amending the regulation, we're amending the implementation of the regulation.
Yes, thank you for that.
That's all right. We're amending the implementation of the regulation to start, to make today the last day of the negotiation period with the arbitration procedures starting tomorrow, is what I take from your motion.
Yes.
Okay. All right, all in favor?
Aye.
Aye.
The ayes have it unanimously, and that motion is carried. I think that's all the business that was mentioned on the agenda.
Motion to adjourn?
Second.
All in favor? There'll be no
Aye.
discussion of that.
Aye.
Aye. Motion is carried. Thank you all.